Hey, so in this video, we're going to talk about 3 reasons why wills or trusts are contested in Louisiana. So I'm Paul Rabelais, I'm an estate planning attorney, and quite a bit people ask me about how they can contest a will because they don't like what the outcome would have been. So what I'm going to do is I'm going to go through the 3 reasons, because when somebody does contest a will, they have to have grounds for their contesting of the will to be valid. So I'm going to go through 3 reasons why wills typically get contested. The first one is people sometimes contest that the testator, or the person who wrote the will, didn't follow the formality requirements. Let's talk about that for a minute, because in Louisiana there's 2 kinds of wills. There's the olographic will, which that's also known as a handwritten will. That's not the majority of wills that we see, but an olographic will, to meet the formality requirements, it has to be entirely written, dated, and signed in the handwriting of the testator. And there's some particular rules on where it needs to be signed, but entirely written, dated, and signed in the handwriting of the testator. Somebody else can't write it and then have the person sign it. There's no notary requirement. There's no witness requirement. It's pretty easy to meet the formality requirements of an olographic will, but it always gets messed up because the do-it-yourselfers, they write something and one word can mess up how things go. So we really encourage people not to do their own olographic will. The second kind of valid will in Louisiana is what's called a notarial testament. Most of the wills are notarial testaments. They're typically typed up. It's signed on each page. There's a notary and 2 witnesses. There's a very important what's called attestation clause at the end that's got to be in there. So we see that a lot. And so if someone attempts to have a notarial testament and they don't meet those requirements, the will could be contested. As far as a trust goes, the formality requirements are a little simpler. It needs to be notarized and witnessed by 2 people. Okay, so that's the one that takes a little extra explanation. The formality requirements, if they're not met, a will could be contested successfully. Number 2 is a lack of capacity. So that's when a person is they're not able to comprehend generally the nature and consequences of the disposition that they are making. So it used to be an old of sound mind and body capacity requirement. That's not the case anymore. They have to be able to comprehend generally the nature and consequences of the disposition that they're making. So, wills and trusts have sometimes they have very complicated tax law language. Lay people don't understand that, but as long as they can generally comprehend the nature and consequences of the disposition they're making, at the time that they wrote the will, then, they've met that requirement for capacity. So if someone's very demented, or they have Alzheimer's and they're not able to comprehend generally what they're doing, then perhaps a challenge due to lack of capacity may occur. And then the third one is related to the lack of capacity. The third reason people contest wills or trusts is due to undue influence by someone. Son says, "Mom, let's go get some ice cream." And she says, "Yeah, I like ice cream." And then after they get their ice cream, he sneaks into the lawyer's office. "Mom, we just got to take care of some paperwork. Sign right here." Mom has no idea what she's doing. Son influenced and had that undue influence over mom. His influence impaired mom's volition. So, often we see numbers 2 and 3 together. Mom has lack of capacity, and as a result of that lack of capacity, someone attempts to exert their undue influence. And so really either one of those, and sometimes we see a combination, is the potential grounds to contest a will or trust. So those are the 3. I got more to go over, but those are the 3. Didn't meet the formality requirements, lack of capacity to generally understand what they're doing, and then someone exerted undue influence, impaired the testator's volition. Now, let me go over one reason where you're not going to be successful when you attempt to contest a will. And we see it a lot, and I gotta listen to a lot of stories. Mom dies, daughter comes into my office. Mom had signed a will 15 years earlier that said, when I die, I leave everything to my 2 children equally. Daughter doesn't think that's fair. Daughter comes in, I got to listen to 45 minutes of Mr. Rabelais. Mom's will isn't fair. I quit my job, she says. I moved in with Mom. I fed her, I bathed her, I changed her every day for 20 years, and I devoted my life to taking care of Mom. And my brother lives all the way on the other side of the country, and we're lucky if he calls on my mom's birthday and wishes her Merry Christmas, but he hadn't lifted a finger for her. It's not fair. I ought to get more than him, even though my mom's will said it goes 50-50. In fact, Mom told me a couple of years ago that she wanted me to have her house. And so I listen, and she goes on and on and on and on, and I don't mean to be rude to daughter here, but done it a million times. So after, they vent, I usually say something like, well, do you want the blunt version or do you want the sugar-coated version? And they're like, well, yeah, give it to me blunt. And then I'll say, you know what, tough. It may not seem fair, but if your mom would have wanted the house to go to you, or if she wanted you to get more because you've taken care of her for the last 20 years, and maybe it does seem fair that you should get more, then Mom should have followed all of the necessary formality requirements and put all of that in her will or her trust. But she didn't. And so we have rules. Rules have to be followed. If they're not followed, there's consequences. So anyway, the fairness objection is, just doesn't fly. So for those reasons that I just explained. Last point before I let you move on and watch some of my other YouTube videos that may even help you even more is just to let you know in advance, we don't get involved in those kind of will contests. Those get nasty. I wore my coat today for this video because when there is a will contest, you get lots of lawyers. They're all wearing suits. They're all suing everybody. They're all going to court together at the necessary hearings. You got a judge who doesn't wear a suit. He or she wears a robe. And it goes on for years, and estates get dwindled down to nothing. Nobody wins. I made a decision a long time ago that wasn't going to be part of our business. We want to focus on getting it right ahead of time. Having people get this done at the right time in their life, and having, of course, meeting all the formality requirements and other requirements, having the right communications with your family so that there is no surprise and there is no one thinking things are unfair, and doing it the right way the first time. That's our emphasis. And so there are many lawyers who are very good at fighting that fight after the fact. It's just that's not what we do. So hope that helps. Feel free to subscribe to the YouTube channel. Longer explanation of this on our podcast, Estate Planning with Paul Rabelais. Go Tigers. Y'all have a great day. Take care.